Today's topic, we're going to talk about liquor liability, and this is going to be Arizona specific. Hello everybody, my name is Dave DiLorenzo. I'm the owner of Bar and Restaurant Insurance, otherwise known as the DELO. And today I have my good friend and I would say almost unfortunately or fortunately work partner,
Yes.
Gary Linder. And Gary is with, I always get it wrong because there's so many names in these law firms, so I put the middle one in the last slot. And anyways, Jones, Skelton, and Hockley.
That's correct.
That is correct. And you are a partner there.
That's right.
Yeah, this is big time. So today, this is the beginning of what we are creating here as far as an educational series for any and everything hospitality. And what I want to do is to be able to provide any and everybody watching a short synopsis of different topics. I've got a list of questions here that I thought were going to be informative and helpful to everybody watching. So why don't we start with the very beginning? What is the definition of Title IV? Like, what's the history of Dram Shop? How did all this come about?
Well, so what happened is that, believe it or not, before 1900, there's actually cases in Arizona that made it where there was no liquor liability responsibility in Arizona at all. And so for years, the common law, we call it, which is the case, that's case law, that's what's created by judges, stood for the proposition that there was no liability for an overservice of alcohol claim. Then what happened in 1983, there was a case that came along called Ontiveros, and Ontiveros created what we called common law liability for Dram Shop. And what that case stood for was the proposition that if a bar or restaurant serve someone so much that they should have known that the person was intoxicated, then they were liable to someone injured as a result of that overservice. So then that was the law for about 3 years. And then what occurred after that is the state legislature decided to try to craft a legal framework to essentially try to establish that case, but as part of Title IV. That's where Title IV came from.
Okay.
It was created in 1986. And so that created a different avenue to be able to sue a bar or restaurant with respect to liquor liability. And what that stood for, and it still is the law to this day, is that you can't serve someone who's obviously intoxicated. And if you serve someone who's obviously intoxicated, you're responsible for injuries or harm caused by that person that's overly intoxicated or people that they might injure. So that's really the history of Dram Shop in Arizona. But there is a recent decision that changes all of that. I don't know if you want to talk about that now or not.
Why don't we talk about that in a minute?
Okay.
And let's talk about just how broad of a definition, obviously intoxicated is.
Sure, and the interesting thing about that is that actually inside Title IV, there's a subsection of Title IV that defines obvious intoxication, believe it or not.
Yeah.
And that definition is very broad, and the definition essentially is that someone's obviously intoxicated if they are showing signs and symptoms of impairment to their motor functions or to their mental acuity. So essentially, it's a very broad definition, but it is one of those things that really is kind of a smell test for a juror if we don't try the case.
Yeah.
Because you can ask, people understand, they've seen people that are intoxicated before, and they can use their own history and training, or their own life experience, I should say, with respect to what to them is obviously intoxicated.
Yeah, very interesting. And so there's probably so many cases that you have seen over the course of, doing law. And I know that you're very much specific with liquor liability. That's
Yes.
how I had found you through a mutual carrier that we had at the time, who no longer does liquor liability in the state of Arizona.
Nope.
But, when we talk about, the Arizona liquor and Title IV and how it's ingrained in the Constitution, how long has the current laws until this recent change, which I'll have you get into, how long have the current laws been in place?
So that old system, the system I was referring to, in which there was two ways to sue a bar, through either the statute, through Title IV, or through the common law, that's been in place since 1986.
Okay. 1986. And now like you said, there's a new case that's, gone through, and I guess it's probably going to go through Court of Appeals now. Is that?
So the case is called Torres, and that case actually was tried, and then it went to the Court of Appeals, and the Court of Appeals made a decision that's now being reviewed by the Supreme Court. Okay. So you're correct about that. And what that decision stands for, what Torres says, is that because Arizona had no common law liability for dram shop.
Okay.
Prior to the drafting of Arizona's Constitution, that when Arizona's legislature came forward in 1987 and made Title IV, that Title IV, what they call as preempted, it preempted that prior the Ontiveros decision with respect to trying to make it out of the common law. So essentially, what the simplest way of explaining it is that that new case, the Torres case, abolished common law liability for dram shop.
Okay.
Which is very, very important because the ability for a plaintiff to discover or to be able to create a claim, I should say, with respect to a bar or restaurant, it's a much lower standard to say that, hey, look, you served them so much that you should have known. Because that gets into counting drinks, that gets into the strength of the drinks, but it has nothing to do with actually seeing someone who's impaired.
Yeah.
And so under that standard, you could have someone who is completely intoxicated, but they're showing no signs of intoxication whatsoever, zero signs, and yet you'd still be held responsible just for the number of drinks that you were served.
Right, right. And do you feel in your opinion or your heart of hearts that this is something that's going to uphold?
You know what? That's a great question. I will tell you that. So in the Court of Appeals, there's something called amicus briefs.
Yeah.
And those, both sides, the plaintiff's attorneys and other sort of like Mothers Against Drunk Driving and whatnot, they're filing amicus briefs trying to overturn the Torres decision. And then the defense bar, as well as I think some of the organizations you're involved with, have also filed amicus briefs. And so it's really it's a new area of Arizona law, and all of us are looking at it very closely and definitely very antsy about what the Supreme Court's going to do. And I don't know.
And what's a 30-foot view of the Torres case? This was something where somebody had gone and fallen asleep at their residence?
Correct. What had happened is that there had been overservice. Overservice was established, but the weird part is that the jury came back and determined that the statutory elements had not been met, but the common law elements had been met.
Yeah.
And so then that went up to the Court of Appeals, and that's how they get to the determination that they abolished common law liability by saying, look, it's preempted by Title IV.
Yeah, yeah. Is everybody catching this? Yes, this can be very confusing, and even after 2 decades of doing insurance specifically for liquor liability, it's still like a lot to follow, and that's why Gary and I have lunch a lot. What's the length of time that somebody can come back and sue somebody's establishment in Arizona?
So that's another interesting tie-in to the Torres case, because for simple negligence, for just a negligence count, a common law negligence count, it's 2 years from the date of the incident.
Yeah.
And so with respect to a slip and fall, a bar fight, anything having to do with those types of general liability claims, that's going to be a 2-year statute of limitations. Under the old system, under Ontiveros, you had 2 years to bring a dram shop claim under Ontiveros under the common law.
Okay.
But forever, because it's another statute, you only have 1 year to bring a statutory claim. So now, because of Torres, the statute of limitations on a dram shop claim is 1 year as opposed to 2.
Really?
Yeah, because it's only by statute, and you have to bring a statutory claim within a year.
Who knows this right now?
Well, the lawyers are beginning to discover it very quickly right now.
Yeah.
And in fact, we've had cases dismissed already from my office where we've gone back and looked after the Torres decision and looked that the plaintiff's lawyers never even pled a statutory claim, and they just pled essentially an Ontiveros common law claim.
A common law, yeah.
And if they didn't plead the statutory claim within a year, the case is done.
The case is done.
Yeah.
Interesting. So this is big for Arizona.
Big.
And really a lot of people don't even know about this right now.
No.
Yeah, including plaintiff attorneys.
That's true. They're getting used to it very quickly.
Yeah, well, maybe they'll see this, and and that's the other thing too. With some of my claims that I see coming, I see them coming a lot faster and harder than has them waiting for the 2-year period to almost be up.
That's why. And multiple carriers that I've worked with have had the exact same experience where they've called me up and said they don't understand why these people are saying, no, I have to file a lawsuit, because they're trying to negotiate pre-lit.
Right.
But they can't because it's only been a year. But I will say this. It's very good for defending and prosecuting a case, quite frankly, to move that statute of limitations up to make it sooner, because you wind up with witnesses that have much better recollections of what occurred on the night in question. The police and things of that nature who investigate are going to have a better recollection a year as opposed to 2 years after the fact. Yeah. And so those things are actually very good. And then last, and we'll talk about this more probably later, but it's better as well as because sometimes you don't get notified of these claims until a lawsuit's filed.
Right.
And so if it's a year, some people have surveillance systems that actually do store stuff for a year.
Yeah.
Now, they didn't historically, they'd store it for a few weeks.
Right. Well, yeah, there's a lot going on with technology and,
Yeah.
and other, types of mechanisms to help people with that. So why don't we get into that right now? Based on what you've seen over the years and some of the cases that you've had to be a part of, what are some of the, I'll just say, helpful processes and procedures that establishments can do to, protect themselves better?
Well, I think it starts with your security. And a busy establishment, a sports barn grill or something, say in a Mill Avenue, a Scottsdale Old Town type location, need to be very, very aware of the fact that it's illegal. It's against the law to allow someone to come onto your premises who's intoxicated.
Okay.
So it starts there at the door, believe it or not. I mean, in terms of having somebody who's qualified at the door of your establishment to pick up on the signs and symptoms of someone who's been intoxicated.
Yeah.
Because they're not allowed into your premises.
Training.
Yes, very, very important. Training, but also, quite frankly, I call it courage. Because it takes a lot of courage to tell someone, look, you can't come inside my bar. And not to mention the fact that that's not necessarily great for business. But what's worse for business is getting sued, for sure. The second thing that I would say to your clients and to the bar and restaurant folks who are watching this is that the concept of last call is a terrible idea, and it's something I've talked to for years about this with my clients and with carriers, and I'll explain. The thing of it is that so in Arizona, obviously everybody knows that you have to stop serving alcohol at 2.
Right.
That's the law. So then what happens is you'll have this sort of rhythm, if you will, of a bar and restaurant where the wait staff, as a function of customer service really more than anything else, will go around to the bar and tell people, hey, listen, last call is coming. And that happens usually around 1:15, 1:20. So at that point, you've got people that have been in your bar for a long time already, right? So they probably have alcohol on board, and maybe too much.
They're ready to go.
And so then, liquid courage, right? And so then at that point in time, a round of drinks will be ordered.
Yeah.
At 1:20, and oftentimes it's shots, which is that's bad too. So then the wait staff or the bartenders then will announce at 1:40, 1:45, this is last call. Last call is happening. So have another round of drinks ordered at that point in time. And then what happens? 1:55 a.m. lights come on, and the security staff says everybody's got to go.
Yeah.
You have to leave. The bar is closed. Well, from a scientific standpoint, I can tell you that the apex of alcohol impairment occurs about 35 to 40 minutes after you take that shot.
Gotcha. Yeah.
And so you can see where I'm coming with this, which is that now someone's got 2 shots on board, and you never even got a chance to see them as a bartender or a server in terms of the impact it's having on them. But guess what? When they're on the road at, say, 2:15 to 2:30 in the morning, the highest BAC they're going to reach is going to happen while they're driving.
Yeah.
So I discourage that practice, the practice of announcing that last call is coming. I discourage the practice of doing anything to accelerate drinking at that point in the evening.
Right.
It's a bad idea.
Yeah.
The third thing I would say, and from a practices and procedures standpoint, is that drink specials and happy hour specials are generally speaking not a good idea.
Okay.
That doesn't look good in front of a jury, and it gives the impression that you are doing and it's probably true. You're trying to accelerate those alcohol sales and accelerate the speed at which people are drinking as a function of making it much cheaper over a certain period of time. Reverse happy hour is the worst idea ever.
Right, yeah.
Because you're flipping that to where people are winding up drinking more later in the evening.
And for cheaper.
Yes,
Yeah. You're just a fun killer, Gary.
That's true.
How big of a asset is having video?
It's huge.
Okay.
And I'll give you an example. Years ago, I had a case up here in Scottsdale where there was a couple that was they were enjoying a Philadelphia Eagles football game. They were Eagles fans, and so they were at an Eagles bar. And so they were very generous. They were pretty well off, and they wound up with a tab of $325 at this bar that I was representing. Well, so she, the wife of the couple, had to go pick up her daughter from school or something, and so she drove away and turned left in front of a motorcyclist and killed the motorcyclist.
Oh, God.
Now, her BAC was like 0.82.
Okay.
It was like
barely
right on the edge.
Yeah.
But I didn't like that tab, $325 tab.
Right.
And, oh, my goodness, what have they done? So she explained to the police officers that she'd had 2 white Russians over the course of 3 hours. That's all she had. And I was thinking, hey, that's good. I hope that's true. But we couldn't tell from the tab because the tab's got $325 worth of drinks on it.
Yeah.
So believe it or not, we pulled the video. The video showed them the entire time they were at the bar, and it showed her drinking exactly 2 white Russians. And that claim cost $0.
Really?
Because there was no, I mean, of course, her insurance had to pay, for her accident, things of that nature. But as far as the bar's responsibility, there's no expert on the face of the planet that's going to say that serving someone 2 drinks over the course of 3 hours is over service.
So let's talk about that real quick. You said she blew a .82, right? And so legal limit is .8.
Yes.
Okay. So in order for a plaintiff attorney to actually even sue somebody on the effects of dram shop or liquor liability, do they have to blow that .8 in order to get there?
No. As a practical matter, yes. And as a practical matter, the higher it is over a .08, the worse the claim is from my perspective. But believe it or not, I mean, you can get cited for being impaired to the slightest degree, which doesn't require you to be over a .08.
Okay.
But I can tell you that the leading plaintiffs experts, the experts that I see over and over again, they do use the .08 standard as indicative of overservice, of saying, listen, if you serve someone over a .08, you've overserved them.
Yeah.
But again, circling back to that new decision in Torres has thrown that all on its head.
Right.
Because Torres says, look, it doesn't matter what the BAC is with respect to that particular interaction. It matters whether or not you serve someone who is obviously intoxicated.
And now with the Torres case, like what are you seeing as far as a plaintiff's counsel coming in and saying these are the things that we show as being served overly intoxicated?
So the big part, the most of these cases are driven by the BAC. I mean, that's the core issue.
Yeah.
And so, I'll see cases with the BACs of, 0.18, 2.2, I mean, really, really high BACs. Those cases are still difficult to defend, even under the current law, even if Torres stands.
Yeah.
Because you have situations to where you're going to have witnesses who likely are going to say, no, I observed this person with bloodshot eyes, loss of motor skills, getting loud, falling asleep, things of that nature. That really, quite frankly, if your bartender says, and it's all about timing too, right? Because if an accident happens, say 30 minutes after they left your bar,
right,
and the police officers are examining this driver, they're going to say, hey, look, because the cops have never found somebody who wasn't drunk.
Yeah.
That's just the way they are.
Yeah.
And so they put in their reports, bloodshot eyes, crying, loss of motor functions, failing the field sobriety tests that they administer, and then of course the BAC. So there's still that issue, and then a subtopic I wanted to discuss about that is that one of the most important experts in a liquor liability case is a toxicologist.
Right.
And so what we haven't seen yet, and what I do predict to occur, is if Torres remains the good law, I believe you're still going to have a situation to where a toxicologist, this is a doctor who specializes in toxicology,
right,
can come in and say, look, here's a stack of studies and surveys and examples of the types of signs and symptoms that people display at a certain BAC. Because they've done, tons of tests and having people drink and then observing them, but these being very, standardized tests. And I still think we're going to have a situation to where we're going to have a battle of toxicologists who are going to say, nope, that person's a 0.17. That means that when he was drinking or she was drinking, he was exhibiting certain signs and symptoms.
Yeah.
The flip side of that is that as people know, and certainly the people that are watching this know, is that everyone reacts to alcohol differently.
Right.
And it has to do with tolerance. It has to do with your experience, your age, your gender, your weight, how much food have you eaten. All of those things factor into the signs and symptoms you're going to be displaying at a certain BAC.
Yeah.
And so that's still going to be an issue for us to fight it out in court.
So talking about that and talking about I know a lot of bars and restaurants would be interested in this, the chain of events. Let's just say, Rick walks into a steakhouse, has a couple of glasses of wine. He's already at that, 0.08 level, ends up going to another place, has a couple more drinks, goes to another place, which is the last place. So 2 questions in this. How liable are any and everybody down the chain? How is that figured out? Can they all get pulled into a suit? And how bad is it to be the last place? And even the last place, even if Rick doesn't show any signs of intoxication because he's able to hold it together.
Well, the answer to your question, several questions there, obviously.
Yeah.
The first one is that really anyone in that chain of service can be sued.
Yep.
So we do see cases in which the first bar, second bar, third bar can wind up being sued.
Yeah.
Depending on, so each individual bar would be evaluated with respect to their service. And so this question of whether or not you serve someone who's obviously intoxicated, that it's better to be at one of the earlier bars than the later bars.
Yeah.
But then it still comes down to how much you serve them, though, because you can still overserve someone as the first bar.
Mm-hmm.
I mean, and we do see that. I mean, in terms of that happening. Under this new system, it's going to be much more rare to see those claims because, again, they've got to prove that the person was obviously intoxicated at that first bar, which is going to be very odd. Essentially, that they got them that drunk immediately.
Or they were drinking in their car or something and didn't notice.
Exactly.
Yeah.
So to answer your second question you talked about is how is it to be the last bar? Well, that's typically the worst place to be.
Yeah.
With a few exceptions, but typically speaking, when you're the last bar, you're sort of that last best chance to keep that person off the road. If we're talking about a drunk driver.
Yeah.
And so you've got the liability associated with potentially with letting someone in your bar at all that was drunk to
Right.
begin with, or showing signs of intoxication, and then serving them more. Now, I will say this, just to kind of take the sting out of it a little bit, is that the way that experts look at this, and even plaintiffs' experts, is unless the person is showing signs of intoxication, the notion of serving someone one or two drinks, something in that range, is not a violation of Title IV.
Right.
Because you haven't seen them that evening. You don't know what signs and symptoms they're showing. And if they come up to you and they seem fine,
Yeah.
you're not charged with the knowledge of where they've been that night.
Right.
And there's nothing out there, no expert's going to say, at least that I'm aware of, that somehow the bartender or the wait staff has some sort of obligation to interview someone.
Right.
And say, hey, before I serve you a drink, let's talk about where have you been, what did you drink? I mean, that's not practical at all.
So even just as important, they come in, they're showing signs of intoxication, they're in your establishment. How long and what do you need to do to get them out so that you can not be liable?
Well, so under the statute, and it's to me, and again, I hate to sound like a wet blanket, but that's another very tricky part of liquor liability law. Because under the law, it says that if you identify someone who's obviously intoxicated, you've got 30 minutes to get them off your property.
Yeah.
And the problem with that is that what do they do after if you kick them out? Because you own them.
Right.
If you've gotten them intoxicated and you violated Title IV,
Yep.
you own them essentially until they sober up. And so, what I definitely recommend with respect to all of my clients is that you got to be diligent. You got to have good training. You've got to have people that know they can speak up on your staff and say,
Right.
listen, there's a problem here. At that point, certainly I encourage all of the establishments to offer free Ubers or free Lyfts or cab rides to these people, to offer to pay for them. There's ways of actually getting a master account with Uber where you can get rides for people
Yeah,
and get them
it's
to
good
their
advice.
houses. Definitely want to do that. Once you identify someone as being obviously intoxicated, you definitely want to offer them water and food. Definitely want to cut them off. Make sure they're not drinking anymore. You want to remove alcohol from them even if they have a drink that's half consumed. You want
Yeah.
to still pull that drink. It's tricky because I've had several cases to where bars have been assured by multiple people saying, no, I'm the designated driver. I'm the one that's going to drive everybody home. And then all of a sudden they go in the parking lot and everybody changes their mind.
Right.
Then all of a sudden you've got the drunk person driving, the designated driver's going somewhere else, or maybe they got drunk too.
Yeah.
So that's a hard thing to rely upon. But DDs are still a good way of if you identify that there's someone who's a designated driver in the group, it gives you an extra layer of protection.
Yeah,
with
for
respect
sure.
to a potential claim.
How important is liquor training for all of your employees?
It's very, very important, both with respect to the practical application of the law and in terms of the way you run your business,
Yeah.
but then also with respect to the way I can go about defending a lawsuit.
Okay.
And so most of my clients now, they all require the bartenders to go through Title IV training, so
Right.
they've got their liquor liability certification. The managers have to go through a higher level of training for the management side of liquor liability training. I will tell you that what's also important about this is so to train these folks, if they will comply with that training, your business is going to be much safer. It just is. It's just, you're going to have much less likelihood of a claim. Bear in mind, though, that with respect to lots of things that we do, that I do as an attorney, plaintiffs' lawyers look for standards and policies and procedures because they want to be able to establish that you broke them. And so when you go get your people trained, it's very, very important they comply with the training. Because then if they get, they wind up testifying, they wind up having to say, hey, look, sure, I was trained to do A, B, and C, but I didn't do it.
Yes, that makes total sense. What do you say to the people that are like, yeah, but if I have that video footage, it could be used against me?
Well, what I can say to that is that the vast majority of the cases I've doing this for 23 years, that the vast majority of the cases, the video is better for us than not knowing.
Yeah.
And the reality is there's always going to be witnesses. There's always going to be people telling stories one way or the other in the plaintiff's story. And so it's very, very important to have that video. The video surveillance is very, very important. Video surveillance is very important. I know it's not necessarily what we're talking about today, but in bar fight cases, because in the melee of a bar fight, it's very difficult for witnesses to remember who did what, when, and how, who threw the first punch, and things of that nature. And so you really do want to make sure those videos are there. With respect to a potential bar who says, hey, look, I'm concerned about having video surveillance because it might hurt me. I know this sounds a little harsh, but I would say if they think that, they probably need to rethink their policies and procedures at their bar. Because if they're worried that the video is going to pick up one of their security guards pounding someone, well, they need to make sure the security guards aren't doing that.
Probably rework, their security training.
The videos are very, very important, not to mention the fact that, like you said before, because this 1 year statute of limitations is now applying, it is fast forwarding the lawsuits quickly. But I do want to caution your clients and other restaurants out there and bars that if they receive one of those evidence preservation letters, it's important not to chuck that in the trash.
Right. Yeah.
If you get an evidence preservation letter, which are very, very common, there's Arizona law on point with respect to your obligation as a defendant, as a would-be defendant, to maintain and keep evidence.
And talk about, in relevance to what I do for a living, talk about how important it is to notify your agent and or carrier when you get those letters.
Well, it's extremely important because what will typically happen is that when you get an evidence preservation letter, you want to submit that to your insurance carrier because your insurance carrier is going to help you with respect to collecting that information. Oftentimes, the insurance carrier will go ahead and retain counsel, like me. And at that point in time, the investigation that you complete is privileged, which is important.
Yes.
If you don't engage an attorney to help you with the investigation, that's all discoverable.
Yep.
In terms of what you did, how you did it, who talked to who, and the interviews and things of that nature. And so that's another important aspect of why you'd want to get that letter to your carrier and your agent quickly.
Yeah, and if it happens, don't be afraid to send it over because, oh my God, I'm going to have a claim on my record. Because at the end of the day, the damage that can do, of actually having your case, looked at and protected is huge.
Yes.
Yeah.
I agree. And typically there isn't anything you can do to make it go away.
No.
You know what I mean? It's not going to get better.
Right.
And so once you get one of those letters, you need to take action.
Okay. Let's talk punitive damages. Let's talk the fact that in my experience right now, most, if not all, policies that I see out there do not cover punitive damages. So Gary, what are punitive damages? What do you have to be, guilty of in order to, have some sort of verdict against you in punitive damages? How does that work?
Well, so I wanted to get this straight to make sure I had the exact language. But there's a new case in Arizona that defined punitive damages, and it's a case involving Swift Trucking. But it says that in order for a plaintiff to establish punitive damages, there has to be proof of the intent to cause harm or that the defendant acted out of spite or ill will. Outrageous conduct will always be required to sustain a claim for punitive damages in negligence cases. And so these are negligence cases, just simple negligence.
Right.
So, which we call torts. But in any event, the punitive damages component to it is an extraordinary, another level of damages designed to punish someone.
Right.
Because under a typical case, under compensatory damages, those are designed to make the person that was injured whole.
Yeah.
So pay their medical bills, pay for pain and suffering, things of that nature, to pay them to make them whole. Punitive damages are a whole different ballgame, because punitive damages, by the definition of it, you can hear it in punitive. It's designed to punish the defendant for that behavior.
And it's basically stating that you did something very evil, like on purpose, right?
Almost on purpose. It doesn't require intentional. I mean,
Okay.
if it's intentional, that is punitive. But really, what from a bar and restaurant standpoint, the most important element of punitive damages that we would see is characterized as outrageous conduct, outrageous behavior. And so, unfortunately, I can tell you that I have had many cases over the years in which the number of drinks served and the witness testimony surrounding that service does rise to the level of outrageous, where we can't get a judge to throw it out.
Wow.
I had a case one time where an off-duty bartender was there. He was overserved. One of the bartenders told the other bartender cut him off. They didn't cut him off. He went to the bathroom and threw up and came back, and they kept serving him.
Wow.
And then he killed two ASU students on the 202. And so that was a case of punitive damages.
Okay, well, we don't want to be liable of punitive damages, folks. Yeah.
No, and you're right. At one point, because the way the law works in Arizona is that if an insurance policy doesn't exclude punitives, it's covered.
It includes it, yeah.
So I agree with you.
It's the same with assault and battery.
Right, and I'm seeing that a lot more with the cases that I've been getting, that the policies are excluding punitives.
They're excluding it, yeah, because of all of this going on. It's a very litigious.
Well, and it's important for your customers to understand that by exclude, that means that you have no coverage for it.
Right.
Which means that if that part of the verdict comes down, the insurance company's not paying that.
Yeah, correct. And it's almost virtually impossible to even get them included at this point.
Is it really?
Yeah.
Yeah.
It's getting bad.
Yeah.
Let's talk about real briefly just insurance companies, your relationships, that you've had with them, what you've seen, and not pandering to them or how great or how bad they are, but just an overall view over the last, let's just say even 2 decades of kind of what you've seen of them coming in and out of the market based on a lot of these, cases that you've had to defend.
Well, I have seen a lot of carriers come in and out of the market, that's for sure. Mostly out, and they don't come back.
Right.
In terms of what happens is that, and my experience has been that I think some of the carriers, they have underestimated how broad and how large the net is in Arizona with respect to dram shop claims.
Right.
And the fact that, for example, another big deal in Arizona is there's no caps.
Yeah.
So some states have caps on how big a verdict can be, how much pain and suffering can be, caps on punitives, or punitives can be excluded,
Right.
different rules. Arizona doesn't have caps, and so there is no limit with respect to how big damages can be. And so with respect to that knowledge, that's actually discouraged some carriers from coming here and writing policies because of there being no caps.
Yeah.
Good news is, though, I think the Torres case is this new shiny toy that we have. That is going to definitely incentivize carriers, I think, to come back to Arizona
and open up the marketplace a little bit more,
which would be
because rates are insane out here, and I'll say that as one that sells them.
Yeah.
But it's also due to the fact that these lawsuits happen, and you would say 99% of them get settled out of court because they're not going to go to trial.
Yeah, I would say 99% either get dismissed, or settle.
Yeah, or settled.
That's for sure.
Yeah.
Very rare they get tried.
Yep, writing checks, baby. Okay, that being said, you've been doing this 24 years?
23 years.
23 years. And you've been, how many, if you had to guess off the top of your head, couple hundred, 300, 400, how many cases have you defended?
At least 200.
At least 200.
Yeah.
Okay, so that's a good amount. Are you able to share maybe something very old, like an old, this is for fun, like an old case or something like that, a story you'd like to share with the audience here?
Well, yeah, I mean, I think this is an interesting case. I've thought about this on the way up here today, and I think it actually kind of it rings different bells in terms of what happens in cases. But I had a case one time that was interesting because it was in rural Arizona, and there were 2 bars that serviced essentially a very large trailer park. This is outside of Tucson.
Okay.
And what happened is that the bar I was representing, there was like 3 people in the bar. It was like a really, really quiet Wednesday night or something like that. Sitting at the bar was an owner of the bar, actually the owner's daughter, I should say, who was also a manager of the bar. She was not on duty that night. And so, she was there as a patron. She was drinking that evening.
Yep.
And so then what happened is that all of a sudden a girl comes. This is all on video. We have the video of it.
I think I know this case.
Yeah, it's all on video. A girl comes in, and this girl is somebody that the off-duty manager knows because she is the new girlfriend of her ex-boyfriend.
You following this? It gets good.
That makes any sense.
I know this case.
And so instantly the off-duty manager gets up and tells her to get out and leave the bar. You're 86 from here. You're not supposed to be here. Get out. So as soon as she does that, she's on duty again.
Yeah.
But now she's on duty and she's drinking.
Intoxicated.
Which is not good. No. That's obviously against all kinds of different rules with respect to the Department of Liquor. But then what happens is they get into a brawl. They start fighting inside the bar. And she's there with her new boyfriend, by the way. The off-duty manager, she's there with her new boyfriend. So then what happens is that the bartender, our bartender that's on duty, that's not intoxicated, she says, go outside, get this outside, which is good. Get them out of the bar.
Yeah.
Well, so they all go outside, and guess what? The old boyfriend is waiting for them outside. Mm. So now you've got old boyfriend, new boyfriend, and old boyfriend's girlfriend all outside at the same time.
This is like drama TV.
Yeah. And so at that point in time, there's a lot of bickering and yelling and fighting going back and forth, but the bartender kind of gets them separated and thinks everything's okay.
Right.
Well, then what happens is that the old boyfriend decides to sucker punch the new boyfriend, punches him, and then runs across the parking lot and gets in his truck.
Yeah.
The new boyfriend decides that he's been wronged and he needs to defend his honor, and so he chases after him. And after the guy gets into the truck, he hops onto the side of the truck, onto the running board of the truck, the new boyfriend does, and reaches inside the window and starts to choke him. Well, the guy doesn't like being choked very much, and so he hits the window. It's a power window on a big diesel pickup, so he hits the window button and ends up pinning the guy's arms to the top of the truck. And then the guy puts it in drive and drives away with the guy stuck on the top of the truck.
This is really sad, actually.
And so then what happens is that the guy changes from wanting to choke him to please let me go. So when he's going about 25 miles an hour, he decides, okay, I'll let him go, and he drops the window, and the guy runs over his head with the back of the truck. And so now that claim, interesting enough, with respect to that claim, when I got that claim really, really early, maybe 2 weeks after it happened.
Wow.
And so I went down, interviewed everybody, and figured out what was going on. And my analysis was that there was no liability because the person who died was our patron, but the person who killed him, ostensibly, was never our patron. He never came in. We didn't serve him any alcohol. In fact, I don't think he was even drunk. So I left the case alone for a while, but then what happened is the Department of Liquor got involved. Mm. And they got involved with respect to that manager doing what she did.
Yep.
And then what happened is, and this is definitely a huge message to your clients, is in terms of what to do in these situations or what not to do. The Department of Liquor comes down and says, hey, look, this is wrong. You've screwed up. You have two choices. Pay $5,000 or whatever it was, $5,000, and sign this consent decree that says, hey, look, I messed up.
Right.
And we've come to this agreement, but you actually admit in writing that you messed up, that you violated the liquor laws, and you pay that fine. Well, the thing of it is, the Department of Liquor says to you, to the owner, and I'm sure so your clients are going to understand this. The Department of Liquor says, look, your choices are pay the $5,000 or maybe we'll take your license away.
Yeah.
How about that?
And you're out of business.
And so it's a simple decision at that point in time. But I can tell you that definitely it's very, very important to retain counsel early in those situations because there's attorneys that do a very good job, and I don't do this, but there's attorneys in town who do very, very good jobs of negotiating with the Department of Liquor over what that document actually says, whether or not you have to actually consent to anything. And so that's very, very important.
Well, that's one hell of a case, one hell of a story. If you want more stories, I'm sure Gary will be happy to share some with you. This has been excellent. I hope everybody gets a lot, if anything, a little bit out of this. Is there anything you want to add before we take off?
No, thanks for having me.
Yeah, that's great. And we're going to put all your contact info on this, this channel and all that. And I, knowing you as well as I do, if somebody does need to reach out to you, is that cool?
Oh, absolutely. Anytime.
Okay, cool.
Yeah.
And so we'll have all that there. And this has been great. Thank you,
Thanks a
Mr.
lot.
Linder.
All right.
Appreciate it.
See ya.